Hello, I'm Michael Scoggin, United States Air Force retired, and I'd like to talk to you about the NSA spying through civilian communications companies. In 2013, whistleblower Edward Snowden made the modern world aware of massive eavesdropping on American citizens by the United States National Security Agency, a seemingly illegal act deemed legal via the Patriot Act. The leaks began in June of 2013 and continued throughout the year. The first program revealed was PRISM. PRISM allows for a court-approved front door access to Americans' Google and Yahoo accounts. Nearly 2 years have passed, yet leaks continue to emerge, informing the public on the scope of the NSA spying as well as its capabilities. Most of the tech-savvy and education population has been outraged. One author describes this illegal spying, stating, "The label lawful illegality captures this conflict between the perspective of the state and the perspective of ordinary citizens perfectly." Numerous cases involving this illegal spying are currently being formed by groups across the nation and civilized world, and there have been 2 court hearings in the U.S. already pertaining to the matter. Metadata is at the center of the spying scandal. CNN describes metadata as information wireless carriers collect about where, when, and to whom customers make phone calls. It doesn't include any recordings of the actual phone call itself. The metadata can contain phone numbers, the time and duration of calls, and the location of the caller and the recipient. But it also goes beyond that. It can include which cell towers were used to transmit the call and what kind of phone was being used. When bundled together, these metadata can potentially reveal a whole lot about a caller. The agency isn't only targeting individuals thought to be harmful to the U.S. security. Rather, it's data mining the endless mountains provided by communications companies. The agency can also retroactively search through archived data. The ACLU is involved and asking how in the world a military spying agency has extended its tentacles into much of the U.S. civilian communications infrastructure. NSA spying began with the creation of the frighteningly vague yet powerful Patriot Act. One of the enduring questions about the ongoing NSA privacy scandals is how exactly broad wiretapping and data collections were even deemed legal in the first place. The answer centers around the Foreign Intelligence and Surveillance Act, a counter-espionage law updated by the Patriot Act to allow broad spying powers for counter-terror efforts. An April 25, 2013 ruling from the Foreign Intelligence Surveillance Court, which is a secret court that rules on all things related to FISA, compelled and forced Verizon to give up all phone records for all of its subscribers for a 3-month period that ended July 19th of 2013. Section 215 of the Patriot Act has been ruled to grant the NSA the power to collect phone numbers and call data, not just subscriber information or location data. Also known as the Business Records Provision, this section allows the FBI to obtain secret court orders from the FISC compelling third parties to produce any tangible thing that is relevant to foreign intelligence or terrorism investigations. In simple terms, vague wording in the Patriot Act is to blame for the spying, namely the hugely controversial Section 215. According to the FISC, because known and unknown international terrorist operatives are using telephone communications, and because it's necessary to obtain the bulk collection of the telephone company's metadata to determine those connections between known and unknown international terrorist operatives as part of authorized investigations, the production of the information sought meets the standard for relevance under Section 215. In effect, a secret court has argued that there are terrorists out there, but because their phone call habits can only be identified by collecting everyone else's phone records, Uncle Sam seems to think it's necessary to investigate both known and quote, unknown terrorists to collect all that data. The government's burden under Section 215 is not to prove that the records sought are in fact relevant to an authorized investigation. The explicit terms of the statute require a statement of facts showing that there are reasonable grounds to believe that the tangible things sought are relevant. In establishing the standard, Congress chose to leave the term relevant undefined. Therefore, the biggest reason the NSA can legally justify its massive gathering of data is because our dysfunctional Congress didn't explain what relevant means when legislating how such collections must be relevant to an investigation. Imagine Boone Police Department getting a secret court approval to search every apartment in town, searching for cannabis, due to the fact that statistically someone in your neighborhood is in possession of weed. And their argument is the searches are relevant to their goal of arresting narcotics abusers. The fact the FISA court would would acknowledge that a privacy law is poorly written and overly broad and then still sign off on it is a slap in the face to American citizens. There have been some court hearings pertaining to NSA spying since Snowden's revelations. The first is the case of Clayman v. Obama, an American federal court case concerning the legality of the bulk collection of both phone and internet metadata by the U.S. Shortly after Snowden brought the scope of surveillance to the attention of the world, plaintiff Larry Clayman, founder of Freedom Watch, filed this lawsuit challenging the constitutionality of the bulk metadata collection of phone records. Plaintiffs joined by Michael Ferrari and Matt Garrison filed a second lawsuit on June 12th that challenged the constitutionality of bulk metadata collection of both phone and internet communications. In the suits, subscribers of Verizon Wireless brought suit against the NSA, Department of Justice, Verizon, Obama, and many others. They allege that the government is conducting a secret and illegal government scheme to intercept vast quantities of domestic telephone communications, and that the program violates First, Fourth, and Fifth Amendment and exceeds statutory authority granted by Section 215. On December 16, 2013, U.S. Federal Judge Richard J. Leon ruled that bulk collection of American telephone metadata likely violates the Constitution of the U.S. The judge stated, "I cannot imagine a more indiscriminate and arbitrary invasion than this systematic and high-tech collection and retention of personal data on virtually every single citizen for purposes of querying and analyzing it without prior judicial approval. Surely such a program infringes on that degree of privacy that the founders enshrined in the Fourth Amendment." The judge ruled that a 1979 case, Smith v. Maryland, which established that phone metadata is not subject to the Fourth Amendment, didn't apply to the NSA program as the U.S. Justice Department had argued. Citing the NSA's vast scope and the involving role of phones and technology, Judge Leon's opinion pointed out that the Fourth Amendment needs to adapt to our modern digital age. American Civil Liberties Union v. James S. Clapper was a December 2013 lawsuit by the ACLU and its affiliate, the New York Civil Liberties Union, against the same. In defense, the NSA claimed that bulk collection of phone call metadata is legal under Section 215 of the Patriot Act, which allows them to collect business records. U.S. District Judge William Pauley dismissed this lawsuit, challenging the NSA's bulk collection, saying that the program is constitutional. The court ruled that phone users had no reasonable expectation of privacy that would give them Fourth Amendment rights. Citing the same 1979 Smith v. Maryland decision, the court found that individuals have no expectation of privacy for information they provide to third parties, like communication companies. Because all the data collected by the NSA is voluntarily revealed to the phone companies by customers according to the judge, they cannot expect it to remain private. Obviously, many now argue this case directly conflicts with Clayman v. Obama, causing further confusion, anger, and frustration. While the ruling in the ACLU case was discouraging for the group, the discussion, debate, and lawmaking is still far from over. The ACLU promises to appeal, and there are more cases popping up all the time. With two federal judges coming to opposite conclusions, yet sharing similar skepticism about the program, it's likely that the legality of the NSA's all-encompassing program will reach the Supreme Court. While the thought of safety and security is comforting, the more we try to protect ourselves from the scary world the more fearful our culture becomes of losing that security, making it more likely for these programs to grow. Ned Price of the National Security Council seems to agree that without 215, the surveillance ends, but he doesn't think it's positive. If Section 215 sunsets, will not continue the bulk telephone metadata program. Allowing 215 to sunset would result in the loss going forward of a critical national security tool that's used in a variety of additional contexts that do not involve the collection of bulk data, he claims. There is hope, however, for those who believe in the Constitution, as the Patriot Act should die in June. The National Security Agency will lose its legal justification for collecting data on Americans' phone and email activity if Congress does not reauthorize the Patriot Act by June 1st. But privacy advocates are still skeptical about whether that would mean an end to the controversial surveillance programs. Congress is poised to renew its efforts to limit the spying powers, but the U.S. Freedom Act aimed at ending that data collection failed to clear the Senate last year. A bill introduced recently would abolish legal powers for surveillance programs, including the entire Patriot Act and the FISA Amendment Act of 2008. The idea of absolute security is absurd and impossible. The only thing we're accomplishing by allowing programs like this to continue is to tear out the pages of the Constitution one at a time. Without regulation and respect for the freedom of speech, the ever-growing and ever-changing field of electronic communications will be an open playground for whatever government entity wishes to exploit it. Americans have fought for hundreds of years for the basic rights they expect. Manipulation of an already controversial act such as the Patriot Act will lead citizens further and deeper into a 1984 situation. Citizens should be allowed to make a phone call without a government entity listening in and knowing the individual's exact GPS coordinates. Without change, we will become an oppressed, albeit highly technological, civilization. Thank you.